and we will resume at 12, at which time...
Briefly, and in a very summarized form, in my grounds of opposition, that is the fourth respondent's grounds of opposition, which are dated. My argument is that the circumstances that the Court of Appeal was trying to interpret were different from what the Supreme Court had in setting the guidelines under the BAT.
Our view as the Law Society of Kenya is that because of Article 2 of the Constitution, and in particular Article 165 on the role of the High Court, anything done under the Constitution is subject to judicial review, whether it is considered a law or a policy question. Anything that is inconsistent with the Constitution, any law, is void to the extent of that inconsistency. And this can be read together with Article 165 that deals with the power of the High Court, and therefore the Court of Appeal and Supreme Court, and says that the court has the power to determine whether anything said to be done under the authority of the Constitution is null and void. So if something is null and void, it cannot be subjected to structural interdict. It cannot be subjected to a mechanism of nursing it into life. It is void for all purposes.
There has to be consultation. That's one. Consultation is a two-way relationship where citizens provide feedback to government. It is based on prior definition of what the issue is and what the citizens ought to respond to. That's consultation. Two, access to information. Access to information prior to making a decision. That is a condition antecedent to public participation. Active participation, that's the last link. This is a relation based on partnership, whereby the citizen will be treated as a partner in governance, will help in defining the process, and the policy considerations, the opinion they give will be respected and considered.
The Constitution predicates and incorporates within its vision the existence of a permanently engaged citizenry, alerted to and involved in all legislative programs. The people have more than the right to vote in periodical elections, fundamental though that is, and more is guaranteed to them than the opportunity to object to legislation before and after it is passed.
Are you telling us that in all cases of invalidity, the courts must suspend the invalidity to allow compliance? And if not, what cases would demand that the courts do so?
On the question by Justice Ibrahim, why the Senate was not a party, because in terms of the proceedings here, I agree with what the Senior Counsel Kiragwa said. But when you look at the record, you will find that there was a joint resolution by the Speaker of the National Assembly and the Speaker of the Senate under Article 1, as contemplated under Article 110.3, that the finance bill was not a bill touching on counties, and therefore this was not an issue that needed to be, because it had the joint resolution had been done, and that's why Senate was not a part in the Court of Appeal. It did not complain, it did not raise any issue on this finance bill, because that had been resolved jointly by the speakers of the two houses. Proceedings of the National Assembly are televised in Bunge TV. So there's that first avenue. And this is a dedicated channel that ensures that everyone who has participated in this process can follow the proceedings of Parliament. Two, the reports of the committees are published and uploaded on the website on what business of the day is coming in at any given time, and so people can follow what is coming in. The Hansard, as my Lady Justice confirmed, is also uploaded. And then there's the audit paper which contains the amendments that have been done and which have been proposed. And then there are the social media handles. Twitter, the National Assembly at KE, that's the Twitter handle. And then there's Parliament of Kenya on Facebook. all this go on concurrently so that people can follow. And there's public access, physical, at the public gallery, that any member of public who is interested in compliance with Article 118 can request and access the proceedings in Parliament to follow what is going on.
Public participation is ongoing. You have the people from the memorandum, the member of Parliament will go to his constituency, and I will tell him, I don't like that provision. Go to the floor. I want you to be substituted with something else. The test, if that is done, the test is not a public participation test. The test is 165 test, whether those substitutions affect rights of other people and those rights, have they been infringed on? Most people don't know this, but Parliament, when it is legislating, especially on the finance bill, each and every clause of that bill is put to a vote. Each and every clause stands on its own. It's a provision of the law. So this court, and it's the same for the appropriation, each vote is put to a vote of the Committee of Supply. Each provision stands on its own. So if this court found one provision to have an issue, which we submit all of the provisions did not have any issue, the court will deploy constitutional severability, because each and every provision is put to a vote and it passes the legislative test.
We will consider the submissions and deliver the judgment on notice. It seems like the Court of Appeal now raised the standard or changed the yardstick and introduced new parameters that were not anticipated in the FIVAN or the BET. The question I'm asking is that a breach of the requirement of public participation when it was not known, or was it a new framework that was introduced to raise the bar? And therefore my question is that unconstitutional, or it is a procedure that was now introduced? Is it a mere infraction because it is agreed there was public participation? It's only that the bar was raised. And when the bar was raised, parties were not given an opportunity now to comply with that bar that was raised.
The Senate is not a party in this suit, in this appeals. Neither, I believe they may not have been involved in the earlier petitions, the High Court, the Court of Appeal, but they are certainly not parties here. They were not enjoined. They didn't opt to join. What are your views about, because any orders on this question, either way, could affect or directions could be given against the Senate. How do you propose that the court navigates that issue, that the Senate were not parties in these proceedings?
By what means does the public receive information as to what may have happened to a bill between the third reading, when amendments are introduced, and presidential assent? What are the steps that Parliament has undertaken to ensure that the information of what has happened in Parliament, including what amendments have been undertaken, is information that is in the public domain, or is it only accessible by Hansard or through the media? In terms of Article 221, which is cast in mandatory terms, were the estimates included in the appropriations bill? Has it ever been done since the enactment of the new constitution? What is the procedure that is normally followed under Article 221?
Say something about the extent of public participation that you consider the law the judgments we have given and the Constitution would consider, I don't think there's a perfect situation, but would consider as satisfactory public participation, so that then the bodies that are mandated to consider it before making a decision would be in a safe position to say this is sufficient public participation.
The judicature, without condoning breaches of the Constitution, should avoid radical rulings that imperil the stability of the state, which is exactly what the High Court did in this matter. When you defund the state by a single stroke of the pen, you defund the state, you empty its coffers. That is not a step that should be taken lightly. It shouldn't be taken where we are quibbling over the meaning of words.
Senior Counsel Kirago Kimani, I had you submit yesterday on the question of concurrence and saying that once the two speakers of the two houses have agreed on a question, then no question can be raised regarding their agreement. I don't know if in the circumstances or case we have before us, and given the back and forth communication between, that you'd say that there was concurrence, strictly speaking.